304 Talk 304, that is the text line. Our friends, the Capitol scribes, as some call them, have been furiously working this morning as Governor Morrissey released the bills that he signed. Also, he vetoed a handful of bills, including several foster care bills as well. They've been sorting through all that. We'll visit with one of those scribes coming up top of the hour. Stephen Allen Adams will join us as we try to sift through what the governor signed, didn't sign, and vetoed on deadline day. Plus, TJ goes back to school. We'll get into that coming up next segment. Yesterday, the U.S. Supreme Court justices heard arguments on the president's attempt to restrict birthright citizenship for children whose parents are in the country illegally. The case was magnified, of course, because the president himself showed up at the U.S. Supreme Court while his lawyers argued the case. Solicitor General D. John Sauer argued for the administration that people here illegally or temporarily are not subject to the jurisdiction of the United States, and therefore U.S.-born children are not entitled to citizenship. At least that was the crux of his case. Joining us on MetroNews Talkline this morning, friend of the show and political science professor at Fairmont State University, lawyer by trade, Robert Bolton. John Bolton. That'd be a heck of an interview. Robert, good morning. Thanks for joining us.
Hey, Dave. Good to be on.
So from what you watched yesterday and what you've read, were the justices buying that argument that parents here illegally who have children in the United States are not subject to U.S. jurisdiction?
I'm sorry, Dave. We just had a phone. Could you repeat that question briefly? I'm sorry. There was an emergency test on our university campus.
No problem. The question, were the justices buying what the Trump administration was selling? That was the question, Robert.
Oh, absolutely not. I'll be very shocked if this is not at least a 6-3 vote rejecting the Trump administration's argument, possibly even 7-2. I think the most telling indication of even President Trump reading the tea leaves is that his Truth Social post a few hours after attending most of the hearing, noting that the concept of birthright citizenship as practiced in the United States is quote-unquote stupid. I will be very surprised if a majority of the justices end up adopting anything remotely resembling the Trump administration's position.
One of the lines yesterday, Robert, from the oral arguments that I think will be remembered years from now, General Sauer made the point, it's a different world, it's a new world, but it's the same Constitution. That's what Chief Justice John Roberts said. Was that the Chief Justice telling the general that may be, but then you need to undertake the process to change the Constitution? The American people need to speak into this. Should it be interpreted that that's what the justice was saying back to the general?
I think that's exactly what Chief Justice Roberts was saying. There are very strong arguments as a policy matter why the United States should not have birthright citizenship. We're very much a distinct minority in the world. Only about 30 countries practice something resembling what the United States does, where if you're born on U.S. soil, regardless of your parents' status, you automatically are granted citizenship. And almost no Western nation, such as in Europe or Western-oriented countries like Japan, pursue that type of policy initiative. It's usually third world countries which frequently have poor record-keeping practices that pursue a policy like that. But what Chief Justice Roberts was saying is exactly that. That, look, yes, this law was passed in the this constitutional amendment was passed in the aftermath of the Civil War to protect the newly freed slaves, and perhaps it has produced some unintended consequences in the modern world, but it's like any other law. If you don't like the policy effects of it, then that's something left to the democratic process and going through the hard work of amending the Constitution rather than just simply with the stroke of a pen on an executive order trying to change 100+ years of constitutional law practice.
Talking to Fairmont State political science professor Robert Bolton. Robert, Along the lines of maybe more of a policy argument, but one that Sauer tried to make was the idea of birth tourism, and that's where people from another country, China, for instance, would come to the United States, have children, so the child becomes U.S. citizen, then go back to wherever, wherever they reside. He brought that up, and the justices asked point blank, well, how big of a problem was it? And when he could not quantify that at all with any sort of confidence, that argument goes right out the window. Even though it's more of a policy argument, you lost the justices there because, well, it may or may not be happening. We don't know if it's a problem or if it's not a problem.
It definitely is, in fact, an issue. I'm aware of a couple of medical clinics on the West Coast in the San Francisco Bay Area that cater specifically to Chinese women who will come to the U.S. on a tourist visa about 8.5 months pregnant. It definitely occurs. Mm-hmm. I have no doubt that it does happen. And even one time as a policy argument is probably too many. But when you're trying to say that this is a major issue and thumping the table that this is something that needs redressed immediately, it's usually not a very good idea to trust the government when they say, hey, we can't provide any detailed justification or give you any numbers, but you just need to trust us because this is kind of the vibe of the moment. I'm not really sure that that's a great way to produce policy objectives.
I'm wondering if you can take us back and briefly summarize. A lot of this goes back to the case of Wong Kim Ark. Can you tell us what that case is and apply it to what we heard yesterday?
Yes, absolutely. And this was actually one of the key points of contention. So if you read Wong Kim Ark v. United States, it is an 1898 case. And Mr. Wong was a person of Chinese descent. His parents had immigrated to China decades prior and were domiciled in the United States when Wong Kim Ark was born. Now, they never became U.S. citizens, but they were permanent residents. Mr. Wong was born here. He eventually returned to Imperial China. He came back to the United States years later, and they rejected his request to be what was the equivalent then of immigration enforcement, rejected his request to come back into the United States because they said he was the child of a foreign country's subjects, and therefore he was not a U.S. citizen, even though he was born in the United States. It worked its way through the legal system and eventually made its way to the Supreme Court, where Associate Justice Horace Gray, who was one of the most important legal scholars to ever sit on the court, wrote the majority opinion and said, in that instance, the parents were undoubtedly domiciled here. Neither party, neither side contests that. And because they were here when Mr. Wong was born, even though they are not citizens, he becomes a U.S. citizen. And this has its origins out of the 14th Amendment's Section 1 language, where the Reconstruction U.S. Congress passed this amendment, which was ratified by the states. And Section 1 was intended to protect those former slaves with the idea, okay, your parents, per the Dred Scott opinion, were not U.S. citizens, but these slaves were born in the United States. We do not want any of the former Confederate states attempting to remove citizenship from them. So we're going to nip that argument in the bud. Mm-hmm. And then 30-plus years later, in the Wong Kim Ark case, the Supreme Court confirmed that particular instance, when people are in the United States domiciled here, there is no question that they are U.S. citizens. Yesterday, Mr. Sauer tried to thread that needle, and the justices did give some criticism of Cecilia Wang, the ACLU's attorney, saying, well, with Ms. Barbara, the woman in this case, she's not domiciled here. Her parents were not domiciled here. They were here temporarily. Is that different? I don't think ultimately that will be a winning argument for the Trump administration, but that is the one distinction that Mr. Sauer was able to latch on to, where if someone is coming here on a student visa, if they are here illegally, there's birth tourism, that may be different than someone who is a permanent resident here. That was the big point of contention and difference between Won Kim Ark and this Trump v. Barbara case.
Fairmont State political science professor Robert Bolton joining us here on MetroNews Talkline. Robert, I guess I'm asking you to look into your crystal ball here. What would the ramifications be? Let's say the justices bought the Trump administration argument and sided with them. What would the ramifications of that look like?
Well, the Trump administration has said that they would only apply this executive order prospectively. So anyone who, say, in the last year was born in the United States of parents who were here illegally or were on a student visa would still be considered an American citizen. Likewise, anyone before that executive order was issued on January 20th of 2025 would probably still be considered a U.S. citizen. But anyone who is going forward who wishes to be a U.S. citizen and has children here, those children, their status, if the Supreme Court ruled in the Trump administration's favor, they would not be considered citizens. And it could be a huge problem. You have many people who have married individuals of a foreign nationality here in the United States and had children here who their citizenship may be subject to question, or if both parents are non-U.S. citizens, undoubtedly people who are coming here as students, as foreign workers, there may be a deterrent, because I do think there is some incentive where people say, oh, I'll come here, I'll get a job, and my kids will be citizens, and there will definitely be no question that they'll be able to prosper in the United States. And from an immigration perspective, there's a general policy of the federal government that they are very hesitant to separate families. So if my kid's a citizen, it's much more likely I'll be able to stay here as well. I do think you would definitely have a chilling effect on people who are interested in coming to the United States and raising families if this order went into place.
Give me 20 seconds on the fact the president was there yesterday. Breaking history, your thoughts?
So there have been occasions in the past where former presidents or future presidents have appeared at the Supreme Court, but it has always been as an advocate. John Quincy Adams, for example, was famous for occasionally arguing before the Supreme Court. This is the only time, to the best of my knowledge, that a president has ever appeared at the court as just a pure witness. Now, I'm a member of the United States Supreme Court bar, so I know based off of the paintings approximately where Trump was sitting, and he was in the right aisle immediately behind each side's advocates at the lectern. I do think it was maybe an attempt to bolster his side's argument, and especially those justices, Gorsuch, Kavanaugh, and Barrett, who had been appointed by him to kind of stiffen their resolve to support his side, but I don't think that will have any meaningful impact. Based off of the questions I heard from the justices yesterday, you might get Clarence Thomas and Samuel Alito embracing the Trump administration's position, and maybe possibly Chief Justice Roberts, although I doubt that one. But I'll be very surprised if this is not at least a 6-3, 7-2 decision in favor of the ACLU and Barbara.
Robert Bolton, Fairmont State University political science professor, friend of the program. Robert, we always appreciate the insights. Thank you so much.
I always appreciate being on. Thank you, gentlemen.
When we return, TJ goes back to school. We'll explain next.